On September the 5th, 2023, defendant filed with the Court of Appeals a motion to suspend his appeal and for leave to file a motion for a new trial with accompanying affidavits and transcript experts. On October the 17th, 2023, defendant Murdaugh received the final trial transcript and very shortly thereafter filed a motion for new trial in the Colleton County Clerk of Court's office. The first topic is an evidentiary hearing necessary at all? The state took the position the answer to that was no. Obviously the defendant not. I have set an evidentiary hearing because I felt like we had to have some brackets on the time we will spend on this matter.
We've argued that their showing in their motion for a new trial is insufficient based on the case law for an evidentiary hearing because there is on its face no sufficient allegation of prejudice. That being said, of course, we fully understand and expect the evidentiary hearing will go forward, and we'll be happy to address burden of proof after the defense makes their arguments.
But when the defendant produces evidence of a substantive communication to the jury by any third party, that's what Reamer is, by any third party, that then there's a presumption of bias, and that the state then has to overcome that presumption, produce strong, clear, and convincing evidence that it was harmless. We find prejudice based on the conduct, not on the juror's testimony, and they didn't use the word presumption, but they found prejudice. And I don't want to get caught up in this issue of do we have to establish prejudice? I think prejudice is established, but the question it has to be established. But the question is it presumed under the circumstances? And if it's presumed under the circumstances, what does the state have to rebut it?
I will be doing the questioning of the jurors, and I will notify the parties pretty promptly what I intend to ask the jurors. The ambit of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her characteristics or personality or anything of that nature. This is a very focused inquiry that deals with this jury and what impact contact, if any, had on this jury.